I'm Nurdin Mohammed Haji, Director of Public Prosecutions. Welcome to the Office of the Director of Public Prosecutions.
The Office of the Director of Public Prosecutions is an independent national prosecuting authority established under Article 157 of the Constitution of Kenya to provide prosecution services and incidental matters thereto.
It is our mission to provide impartial, effective, and efficient prosecution services to all Kenyans. Hence, the introduction of a 3-month course that will take you as inductees through a rigorous training program aimed at equipping you with the skills requisite to effectively discharge your mandate. The mandate of the ODPP is to prosecute criminal cases and get investigated by investigation agencies in all courts except the court-martial, while protecting the interest of justice, upholding the rule of law, preventing abuse of the court process, and protecting the rights of all parties involved.
At the helm, we have the DPP. That is a constitutional office. He has a security of tenure of 8 years, and his appointment is competitive, as you know, and has to go through Parliament, and then appointment by the President. So the ODPP Act provides for the other structures of the office. So we have 4 departments under the DPP. 3 of them deal with technical cases. That is the offenses against the person, economic, international, and emerging crimes. And then we have the county affairs, because we are now in the 47 counties. It is also headed by a deputy director. And then we have the central facilitation. So we have 4 departments on this side. On this other side, we have the SPP. So we have, at the headquarters, we have the DPP, we have the 4 departments, then we have the SPP in between, who is myself. We are present in all the 47 counties and all the 120 court stations, because as you know, we took over prosecution from police prosecutors. We also took over the charging process. So we are present in all the courts. Now, within the different departments, we have divisions and thematic units that deal with different offenses and different thematic areas.
The DPP's office is central in the prosecution of cases. We have responsibilities under the National Council on Institution of Justice, that is NCAJ, where there are many partners: the judiciary, the police, the DPP. We work together in this criminal justice. This is the criminal justice sector.
We prosecute under legal framework. We have the Constitution, we have the Penal Code, we have the Criminal Procedure Code, and many other acts of Parliament. And also practices. We have also principles of law which have been developed through precedents, decided cases. And as a prosecutor, you have to ensure that justice is met, and justice can only be met by applying the rule of the law.
The most important role of a prosecutor is making the decision to charge by applying the 2-stage test. Prosecuting itself, presenting the prosecution side of the matter by calling witnesses to testify in court, presenting evidence, and explaining to the court the details of the alleged crime. The prosecutor's duty is not to obtain a conviction at all cost, but to ensure that the trial process is fair to all, that evidence is presented thoroughly and accurately, and the integrity of the justice process is maintained.
A matter is first of all reported to the investigators. That is the gate to the criminal justice. You are arrested, a criminal offense is reported. They investigate the offense and they compile a file. Now, when they compile the file, they bring it to the Office of the Director of Public Prosecutions to make the decision whether or not there is sufficient to go to court, sufficient evidence to go to court. So this is done prior to the charging in court, because it is after making that decision that you will choose which charge is commensurate with the facts. So when the files come to you, you look at it and you ask yourself, I must first of all satisfy myself that I've got sufficient evidence. For example, if you have exhibits, the chain of custody, so you have to make sure that you have sufficient evidence with a reasonable prospect of conviction. And those are some of the things you look for. After that, you'll ask yourself, is it in the public interest that this matter must go to court? Because you can have sufficient evidence, but it's not in the public interest.
Public interest is likely to be misunderstood here. It does not mean what the public wants. It does not mean the public activism that the public wants so and so lynched. The public wants to see blood. No, when we talk of public interest, we mean that there are certain factors which you consider even when you have evidence.
And normally the guiding principle here is some authority by the Attorney General of England in 1950 called Shawcross. And he said that it is not a must that all cases where there is sufficient evidence we must prosecute. We must consider the public interest. Once you have passed the public interest test, you either go to court or not go to court. But there are some instances where an offense has been committed, it has been reported, you have sufficient evidence. But according to the provisions of the law, there is something important that you need before you can charge the person.
The threshold test. This test is only applied where you have some evidence and there is a realistic prospect of getting some other evidence. So that even if you don't have cogent evidence now, there is a realistic prospect of securing this evidence in the near future.
With the increase of the parties to the criminal justice system and the increase of offenses and emerging of new offenses, we also have to innovate how to deal with them. Not all of them can go through the court. You also realize that even offenses have been created within a family, which were not there before. So you ask yourself whether is the court and prosecution the best way of dealing with them?
We have a number of alternatives which may be employed to reduce the piling up of cases and backlog. The first alternative to prosecution will be diversion. Diversion is a process whereby you enter into an agreement with a wrongdoer or a suspect, such that instead of taking the person through the criminal process, because this person, for example, requires rehabilitation. For example, addicts. These are people who need assistance. So it's not enough to have these people prosecuted in court because it doesn't help. These are people who need help. The second one is what we call plea bargain. Plea bargain is commonly misunderstood by many people. People think that this is a mechanism for cutting deals between accused person and prosecutor. But in reality, plea bargain in other jurisdictions, for example in the US and the UK, resolves over 90% of the cases. 90%. Because in plea bargain, you are negotiating with the prosecutor as an accused person to find an alternative or a shorter way of resolving cases rather than going through the full process where the suspect admits committing the offense in return for some concessions from the prosecutor.
It is not an alternative because the person is pleading guilty, but it's an alternative to trial. It also will declog the cases. Sometimes, for example, the offense that is being committed is an offense of compliance, regulatory offenses. So we would rather the person complies. So compliance is also an alternative because when you don't comply is when you are charged with a criminal offense. Another alternative would be that we go for the asset forfeiture and confiscation. So we decide to go in rem, which means we are going against the asset but not the person. We are also looking at making petty offenses be dealt with in any other way. You find in most countries the investigators and the police have powers to warn at the police station. The prosecutors have administrative sanctions within the police station without taking somebody through to trial. So there are many alternatives that we can apply.
If you look at our mission, we are supposed to offer an efficient, effective, impartial prosecution service. If you also look at our vision, we are supposed to be just, fair, in the kind of service that we offer, that is the prosecution service. So that's a standard that has been set by our office. And the way to know whether we are complying with the standard we have set for ourselves is to allow the people who are using the service to give us feedback. So we have allowed them, if they are not satisfied with our service, they can bring the complaints to our office. And then we receive them, we document them, we process them, we follow them up, to ensure that if the issue that has been raised is genuine, then we correct that. Then also on compliments, we are really also encouraging our people that if you see something good that we are doing, also speak out about it so that we begin to know where are these centers of excellence within our organization and hopefully make them thrive.
As you know, most of the cases we handle, some of them are very sensitive. So we take majorly the security of the case, the files. At least the area is always under, we lock them, and it's only we deal with the need to know basis. The files are given only to the officers who are supposed to act on them, and even when they are requesting, we only give to on the need to know basis. They are only handled with the officers who are designated to handle such cases. If you don't take that measures, any other person can come and you know the nature of these files. They can either interfere with the witnesses. The file can even disappear, and that one, a file disappears, you know the case is bundled.
The DPP prosecutes about 250,000 matters annually with a conviction rate of about 92% as of 2017.
When the Constitution 2010 came into being, the office of the DPP was born, but we started with a very small staff complement of less than 100. Today, we are more than 500 counsel and more than 300 support officers, those who support the counsel in the performance of their core mandate, that is prosecutions. It's unprecedented to have around 20 high-profile cases filed in a span of around less than 6 months. We have taken 2 ex-governors to court and 1 sitting governor for corruption cases, not to talk about the murder cases that is ongoing. We have also taken some members of parliament to court. We have taken several national and county government officials, cabinet secretaries, and private entities, and even private members of the society to court.
As an office, we are doing our best. We are trying within our means. As I said, resources are limited, but it's a problem across the board and across the world. There is no country which has enough. We'll work within our means, what we are able, make the best out of our situation so that we can deliver speedy and fair criminal prosecution services to the people of Kenya.
My vision for the ODPP is to lead it into greater heights of achievement through strategic, administrative, and operational leadership. Ensure the fight against corruption continues and is sustained. Build capacity for all staff members. Ensure effective, efficient prosecution of all cases by fostering interagency collaboration, cooperation, and coordination with all the stakeholders in the criminal justice system. I wish you all the best in your endeavors. I expect that as inductees, you shall acquire the requisite skills to discharge your duties effectively with utmost professionalism, integrity, high fidelity to the law, and ensure justice for all. This is what Kenyans expect, and I expect nothing less. Good luck, and God bless.